I appear in writ petition 1068 of 2019 on behalf of Soeb Qureshi. Soeb Qureshi is an advocate on record of this court as well. He's from Kashmir. There are a large batch of petitions before my lords, which includes people who are not only from Kashmir, who are not only politicians. It includes a former Home Secretary from Kerala. It includes professors, educationists, etc. The reason why I mention this is this case, the way we see it, is not a case only for Kashmir or Kashmiris. It actually opens a vista to many multifarious abuses that the executive can heap on the Constitution if the means that they have adopted were to be utilized in future as well. There is a principle called obsta principis, which means that whenever anything that is approaching or encroaching upon our rights starts, you must nip it in the bud. That's the reason we are all here, because this is an encroachment on something we cherish the most, which is our Constitution. Kashmir is just an example or an avenue for how that is done. And I will seek to demonstrate how that is. Now, your lordships were right when you said I've been here for 12 days, but your lordships have also been here for 12 days. So I've seen all the arguments that's come before mine, which is why I've managed to cut and crop a lot which has already been covered. I will largely be adopting the arguments that have been made by Mr. Chandradeh Singh and Dr. Dhawan and Ms. Nitya Ramakrishnan. I just wanted to tell your lordships before I start that there are some documents which I won't take your lordships through, but you may note it. I mentioned this on the last occasion, which will, I think, benefit the court when eventually you are drawing your conclusions, my lords. Mr. Ramachandran had at length gone through this matter, and he created two lists of dates, a short list of dates, which is at page 17 of the written submissions, volume 1, and a long list of dates where he extracted from every single document the relevant part and put it together. That's at page 32 of the long list of dates. So page 17 is the short list of dates of the written submissions, volume 1, and page 32 is the long list of dates.
The long list of dates is what Mr. Sibal took us.
No, it's different. This is different. This is from Mr. Ramachandran's submissions.
Right, this was volume, page 32 of
written
volume
submissions,
2.
volume 1. Mr. Sibal's is written submissions, volume 2.
All right.
So in written submissions, volume 1, you have page 17, which is short list of dates, page 32, which is long list of dates. Then, my lords, VP Menon's book on integration of Indian states, Mr. Prashant Sen referred to yesterday, a couple of pages. I wanted your lordship just to note that there are two chapters. One is chapter 20, which deals specifically with Jammu and Kashmir. A most remarkable man. If you see his writing, despite him being first person there, you would never find any value judgments being made. It's only purely descriptive of everything that took place. So chapter 20, which starts in volume 15, PDF page 1257. Volume 15, PDF page 1257 is chapter 20, and at PDF page 1304, same volume, is chapter 24. Now, the second chapter deals with how the actual integration took place, the mergers, accessions, etc. The third document, which I think would benefit, my lords, is the white paper. Now, the white paper is the entirety of volume 4. So documents volume 4 is entirety of white paper. My associates, in fact, have gone through them para and verse and have created a table.
Above para 224, there is that chapter on territorial integration.
Territorial integration, exactly. Now,
just give me that reference again.
That's white paper, volume 4, my lords, the entirety of volume 4.
Yeah. That's 1951.
Yes, my lords. Then this is not part of the compilation, but Granville Austin's book on the Indian Constitution, which is the first book, now Working of the Democratic Constitution, second one. But the first one, which is definitely there in the libraries,
Cornerstone,
is 243 to 254.
Just repeat the pages again.
Pages 243 to 254, my lords.
Of which volume?
It's
You're
not,
referring
it's
to the
not,
original, you're referring to the book.
it's the book separately. Now, one separate point, just because we are on this history bit, my lord, the Chief Justice yesterday asked for the background of the Union Territories, and we were trying to assist. In NDMC, the 9 judges judgment, my lords, which is on record, it's PDF page 229, volume 14. Volume 14, page 229. From paras 8 to 19, the entire background and sequence of how we came up with the 7th Amendment and the Union Territories is there, which deals with 1919, the 1935 Chief Commissioner's provinces, all that. So that I think is helpful.
Paragraphs
8 to 19. I'm sorry.
8 to
8 to 19.
which page?
That's page 229 of volume 14. Whoever has volume 14. Lastly, again on that point, yesterday, my lords, we had shared the photos of that original constitution with the schedules.
Yes.
Now, if you noticed in the schedules, they keep referring to section 290A of the Government of India Act, because all those are states which have been added by virtue of section 290A. Now, strangely, it's not part of the Government of India Act, which we have as part of our documents, but it is part of the white paper. So in the white paper volume, PDF page 77 is where your lordship will find section 290 capital A, which was inserted for that purpose. Because I'm appearing for an advocate, I feel it was my duty, and this is what the instructions I have from aforementioned advocate, to ensure that, my lords, we must be careful when we are assisting a constitution bench to ensure that the court avoids pitfalls. Now, it would not be fair of us to present a case which is not supported by the precedent or which the precedent has specifically squashed, which has happened, and I'm afraid I'll have to do that fairly unpleasant task of differing from some of the counsels who came before me on a couple of points. I want to clear that up right now. The first, Mr. Dwivedi, he made arguments, my lords, with reference to 370 clause 3 not surviving, and the entirety of 370 therefore not survive, that the entirety of it had come to an end. Your lordships had said constitutional practice would trump that. There was subsequent constitutional practice. But I'm afraid this was the exact argument that was taken before this bench, and where your lordships passed the order in the Shah Faisal matter when the reference was sought. Now, the reason is Sampath Prakash, which is the 5 judges bench, had that argument taken before it, saying that 370 has come to an end. So you couldn't pass any orders after 1957 by advertence to 370 clause 1. Sampath Prakash squarely rejected it. And when, in fact, a couple of our colleagues had wanted to have that reference, we also argued, as did the government, that it should not be referred. There's no conflict. This position is fine by us. So in fairness, I must tell your lordships that the Shah Faisal judgment is in volume 17. It's PDF 42.
Could you repeat that again, please?
Volume 17. Case law volume 17.
Yes.
PDF 42. The extract of Sampath Prakash is at para 40. And Sampath Prakash's reasoning is that CO 44, which was the 1952 CO, if your lordship will remember, that was the one issued under Article 370, Clause 3, the 1952 one. Thereafter, in 1954, with the Constituent Assembly, they issued 371D, the 1954 order. Now, the 1952 order is proof of the fact that the order itself says that we allow 370 to continue to stand except for this modification and that explanation. Your lordship will remember yesterday that explanation much was being made of it. So it was the conscious choice made at that point in 1952 by the Constituent Assembly, because that's the threshold. That's when we are going to go ahead and make the constitution. Now, if we are going to activate 370 clause 3, why embark on this exercise? we get the entire constitution to apply. But because they made that conscious choice in 1952, they issued that, the one and only order that's ever been issued under 370 clause 3 until 2019, which is the 1952 order. Now that 1952 order is the reasoning adopted by the Sampath Prakash bench to say, since you yourself have taken the decision that the Constitution of India will apply with exceptions and modifications, and the only exception or modification you have brought in is that explanation, which was a question that fell in Damnu later. But because you yourself have said that, it's an accepted fact that 370 continues to apply. That is your conscious choice. I'm corrected to say it's a declaration, Malaz, not an order. It's a declaration under 370 clause 3. And at para 44 of Shah Faisal, para 40 is where this extract of Sampath Prakash is. CO 44 is referred. And at para 44, your lordships have given that as the reason why you're not referring this to a larger bench. The third reason given in para 44. The second, again, I'm afraid of, I'm sorry for the broadside, but I have to be accurate on this. Article 357, there was an argument taken by Mr. Parekh yesterday. And he was saying the part of it doesn't apply. In fact, it does, which, if your lordships recall, how they issued these orders under 371D was they chose the part and said the part will apply subject to A, B, C exceptions or modifications. So they would refer to the article under it and then make those corrections. If you compare page 18 of volume 3, which is the first order, when 357 was not made applicable, with page 38 PDF of volume 3, so that's 1952, I think, and 54 first, and then 1958. Now, page 38 is 58. They, while bringing 357 back, 360 is omitted. So 357 continues to apply fully. So it wouldn't be appropriate for us to argue that 357 doesn't apply in the state of Jammu and Kashmir. In any event, when you see volume 1, page 188, which is the documents dealing with how the Constitution of India applies to Jammu and Kashmir, that page you'll find 357 there, as it is.
Volume 1, page 188, right?
Yes, volume 1, page 188. So, my lords, the points that I'll deal with, I'll just unfold for your lordships. There are some which I've decided I'll leave for rejoinder. I won't trouble your lordships with that because that can come at any stage. It's not a particular thing that needs to come first up. Lords, on history, there are a couple of points that I wanted to make. In fact, I have put all my oral arguments.
Mr. Nurani, I was reading in the morning when,
Yes.
somebody cited Nurani's book.
Yes.
Mr. A.G. Nurani has, of course, criticized the judgment in Sampath Prakash.
Yes.
On the ground that he says Sampath Prakash ignores the first judgment.
Correct. Correct. It is. That is the argument that was taken, seeking the reference. But since we
That has been now rejected.
now that has been declined, I think we'll go by what the judgment,
What now, of
what
course,
they say.
yes.
So I believe those judgments do help us. There are portions of it which have already been read to your lordships. So I don't think I should trouble your lordships with that. Now, my lords, what I've done, I just want to let your lordships know, because I could share it with your lordship, but I needed your permission first. I've made a document of my oral arguments, which will, because I saw your lordships were grappling with going to volume and pages. So we have taken pictures of each page and put it in the note itself. So you don't have to go anywhere else. Plus, there are tables, including what you asked Mr. Zafar Shah, the comparison. So there's a 70-page document comparing the Constitution of India, Constitution of Kashmir, and Constitution of Jammu and Kashmir, showing what provisions would continue to apply, which may be different or in some cases better, as far as Jammu and Kashmir are concerned. Now, I have the document here. it would make it easier reading if I am permitted to share that with you. Otherwise, I can just do it like this because I know your lordship. This is not a written submission. There are no arguments here.
Okay, you can.
Rather than going to and fro from documents and volumes, it's all put in one place.
And you have it in the soft form?
I have
soft
it.
copy? Okay.
I have the soft form. It's ready to email if I can do that.
All right, we'll ask him. So we'll label this now. Fixed, right?
So one page note is not a problem, but if it is something to.
No, it's not. It's not written submission.
Because we would have done it ourselves, but if anything.
No, I'm saying I put
anything to-
pictures. But only reason is your lordship.
Pictures from the existing compilation. Right?
In every place, I put volume and page number, so your lordship can see it's from that volume and page number. There's no arguments, no arguments at all. It's just the sequence of
Just putting it everything in
yes,
one.
yes, in one place. And for the annexures, which is as per everything here is a response to the questions that came from your lordships in the last 12 days. Everything except one last segment, which is completely different, but everything else, which is why it's only a response to the questions. I think we have to assist your lordships now. So it's been sent, so it will be shared.
Chetan, मिला है कुछ?
Meanwhile, I'll just explain to your lordships how I'm dealing with it. There's a little bit of history, and one I think which is very important, which is the previous attempt in Parliament to omit Article 370, in which there were debates in detail. And Mr. Gulzari Lal Nanda, who was the Home Minister then, this is between his 2 tenures as interim Prime Minister. He, as Home Minister, says that there is no way that we can go ahead and repeal or omit Article 370.
Durrani is also referred to that part.
Yes. In fact, I think just before me, Mr. Beg referred to that tunnel that came from that answer to that debate. So the history, I think some aspects of this history may be relevant to be looked at. Also, some of the speeches given in the Jammu and Kashmir Constituent Assembly, you've seen a few, but I think it rings true. All of them repeatedly are so happy, and they always say there are applause and there's cheers about the fact that they joined India. There's no question about any kind of secession, any second thoughts about it, etc. The fact that Sheikh Abdullah in 1972, after his prolonged incarceration, when he was to come back and form the government, they entered into an agreement, Sheikh Abdullah and Mrs. Gandhi. And it's interesting because that agreement provided for the fact that there'd be no question of you asking for an abrogation of 370 clause 3. The accession is absolutely complete. No secession arguments can be taken. That's also put on record, the Sheikh Abdullah and Indira Gandhi agreement. Interestingly, Indira, on behalf of Mrs. Gandhi, the signing of that agreement, which happened the day before he took over as Chief Minister, was done by Mr. Parthasarathi, who was a famous diplomat, but also was the son of Gopal Swami Iyengar. Many ways that you find overlaps throughout, but this history, I think, shows and resonates how from then, that date till now, the interpretation of 370 has been consistent without any departure. 370 clause 3 is the temporary provision. A choice had to be exercised at that point of time, which was done, and it was over and done. And the problem is the other way around. If I may just digress for a minute. 370 clause 1 says Article 1 will apply. You can't make any changes to it. And it starts with a non-obstante clause. 370 clause 3 also starts with a limited non-obstante clause, which says notwithstanding anything in the provision above. We are looking at it throughout while the arguments are on, with reference to the question of complete integration or the constitution completely applying. Why don't we look at it the other way around? Suppose you had some government at the center, which for reasons best known to them, have a sympathy to the cause of secessionism and say that, look, we will artificially create some assembly to be treated as the Constituent Assembly. They will take a decision whether 370 clause 3 can be utilized to abrogate 370. Now, when you abrogate 370, please note that Article 1 also goes with it. The other way around.
There is a problem, Mr. Sankaranarayanan.
Yes.
Article 1 is a permanent feature of the Constitution,
Absolutely.
right?
Absolutely. Yes.
Now, what was the reason for Article 370,
Yes.
Clause 1,
Yes.
to contain a specific reference that Article 1 of the Constitution shall apply.
Yes,
Article 1 of the Constitution was in any case applicable because that's an embedded part of the Constitution.
absolutely.
The reason why they introduced a reference to Article 1
Yes,
in the in Article 370
Yeah.
was for this, that during that interim period when there was a power to modify the provisions of the Constitution,
yes,
those relatable to the instrument of accession with consultation,
yes,
those not relatable to the instrument of accession with concurrence,
yes,
during that period, there would have been a doubt as to whether or not Article 1 could also have been modified with concurrence.
correct.
So the object of putting that in Article 370 was to redouble the constitutional statement that Article 1 is a permanent feature of the Constitution.
Yes,
Now, if Article 370 was intended to be permanent,
yes,
there was no reason to include Article 1 in Article 370 because Article 1 anyway is a permanent feature of the Constitution.
absolutely right.
Just,
If, I'm
just
sorry.
one more.
Yeah.
You see, when we refer to Article 370 Clause 3,
Yes,
it only refers to 370.
yes.
It doesn't refer to Article 1.
No, it doesn't. Correct, correct. But 370, which includes within it, Article 1 compulsorily applying.
But that if one looks at it, the argument which you raised, if one looks at it, what you can abrogate is Article 370,
Correct.
not Article 1.
That's what I'm
So
saying.
370 goes, the entire constitution becomes, as it is applicable to all the states, will become applicable to the state of J&K.
Which is why, if I may just read that, and
if
this
suppose-
is not my interpretation, this is the President of India's interpretation, Rajendra Prasad's. His letter is here, I'll show you the extract. His interpretation writing to Pandit Nehru. But allow me to just show your lordship for a minute, 370.
You will
because
never,
it'll
you will
come
never attribute to the Constitution
Yes,
the use of a surplusage,
absolutely.
right? Every
Absolutely.
word in the Constitution, we apply that principle to an ordinary statute of the legislature.
Yes,
More so to the Constitution that you would never attribute to the Constitution makers any intent to use a surplusage or something without meaning.
absolutely.
And the reason why Article 1 is specifically referred to in Article 370 is
Yes,
that during that interim period, while other provisions could have been modified, it's very clear that Article 1 will not be modified,
absolutely.
which is a clear indicator of the fact that 370 was never intended to be permanent.
I'm with you,
Probably
lordship.
your argument could be
No, I'm with you.
that,
lordship.
that
Yes.
after the Constituent Assembly arrived at an understanding, something further was left to be done by the Indian Constitution.
Right. So
Now, which was never done, and we followed this expedient of the COs.
Yes.
That's what seems to have happened.
Yes.
It served everybody's purpose. The government of India could get the work of the government done. The J&K Assembly could have those beneficial provisions of the Constitution apply to them.
Yes.
As the then Prime Minister Nehru said, that's now reduced to a shell.
yes,
That's what he said.
that's true.
Now, as a result of what this seems to have therefore been a very convenient expedient of having COs to apply the Constitution to Jammu and Kashmir and progressively bring J&K
Correct.
into the mainstream
Yes.
and integrate it fully
Yes.
on whatever issues that were left out.
Yes,
But possibly, these are clear indicators within, intrinsic to Article 370, that these were in the sense of pro tem provisions until some further action would be taken.
this is absolutely right. In fact, if your lordships would see from 379 onwards, fortunately, this book is there now. They've all been repealed, 379 to 390. Those were also pro tem provisions dealing with the provisional parliament. In fact, the converse of
Yes.
the converse of what was shown to your lordships earlier about the explanation provided in Jammu and Kashmir of where the Constituent Assembly of Jammu and Kashmir would conduct itself as the legislative assembly. The identical provision is Article 379, which stands repealed, which is that the Constituent Assembly of India would be the provisional parliament and they would elect the President of India for the time being, etc. Now, those are pro tem provisions. I'll show your lordships that in detail. But on this point, the question I ask myself is 370 clause 3 provides, and those opening words are very important, notwithstanding anything in the foregoing provisions of this article. Now, that I think segues exactly with what my Lord the Chief Justice said. Wouldn't this be surplusage? What was the need for these words? The need, in my view, for these words, because what is it in the provisions above that are standing in the way of 370 clause 3? it appears that 370 clause 1 has excluded the possibility of Article 1 and Article 370. 238 anyway had gone by that. Of these two provisions being in any way the subject matter of orders under 370 clause 1 subclause D. It had excluded it. What 370 clause 3, and I have to look at it keeping two things in mind. 2023, when I'm making this argument, and the fact that Sampath Prakash as well as your lordships have held that this position of 371D being operationalized is the position, that's a correct position. There's no way of questioning it. If I keep those two parameters in mind, the Constituent Assembly sitting in 1952 is faced with the choice which is provided under 370 clause 3, which is that notwithstanding anything in the provisions above, you have to decide whether you want to keep 370 alive in some form with exceptions or modifications, or do you want to junk it as a whole? Now, if they were to take that other choice, and we are grateful that they didn't, but if it was a question of doing so, what is the impact on the Article 1 not being made applicable? What is the impact on it? The way I see it, the impact is, and it's an unfortunate answer, the impact is that Article 1 wouldn't apply to them if they had decided so. And in my view, that's the danger of recreating a Constituent Assembly at any point. Article 368 in our Constitution doesn't permit repeal of the Constitution. Please see. It says amend, modify, repeal any provision of the Constitution, not the Constitution itself. And after the basic structure has come, there's no question of that. Now, what is our fear with this Constituent Assembly argument? It would be very difficult for this court to give a verdict on the Constituent Assembly being resurrected as far as the state of Kashmir is concerned, and in a future date tell us that no, that's a principle that applies to Kashmir, it doesn't apply to the Constituent Assembly of India. My view is it applies squarely to the Constituent Assembly of India. There is no question of suddenly reviving or resurrecting the Constituent Assembly of India in any fashion. It's done for. What you want to do, you do by amending this Constitution. This is something we and our forebears have tied ourselves down to. That's the idea behind the basic structure. There is no way of incremental modifications being made by virtue of resurrecting Constituent Assemblies. This case is effectively about, one, whether a power exists, and two, has the procedure laid down for the exercise of that power been followed? In Article 3, for example, there's a question that Justice Kaul put to Mr. Chandrachud Singh yesterday. Converting a state into union territory is a lack of source of power that doesn't exist in the Constitution. It can't be done. But, subject to what Justice Kaul said yesterday, can you take a part of a state and convert it into union territory? Yes, you can. Article 3 provides for it, but there is a procedure for exercise of that power. That procedure has not been followed. I hope I'm making myself clear. So there's a source of power, whether it exists or not. And then there is the exercise of that power. The same argument applies to Article 370. Does the prospect of creating a Constituent Assembly exist today vis-a-vis Kashmir or vis-a-vis India? No. My answer is a square no. That's not provided for in the Constitution, therefore it doesn't exist. In any event, and without prejudice to that argument, the exercise of the power and the manner of exercise of that power is one of the most fraudulent, invidious exercises that we have seen in this country since 1970. And why do I say 1970? In 1970, when they wanted to get rid of the Privy Purses, they moved a Constituent Assembly bill, amendment bill. That bill went to the Lok Sabha and passed through the Lok Sabha. It went to the Rajya Sabha and it was defeated by one vote. One vote. And then what did they do? Overnight, the president issues an order under Article 366, definition provision of the rulers, and uses that power to say from tomorrow onwards, there are no rulers, all your Privy Purses. What have they done differently today? They just use the next provision. They use 367. And your lordships came down like a ton of bricks on them. 9:2 you held against that kind of an action. And I want to show your lordships Madhavrao Sindhya because I believe it squarely applies. They finally had to go back to the drawing board. They had to come with a constitutional amendment. That constitutional amendment was sustained in Raghunath Rao Ganpat Rao 20 years later. But the fact is, following procedures laid down in the constitution are sanctified mechanisms which protect us, which protect this constitution. The sovereignty doesn't go to the executive. The executive is a creature of the constitution, as is this court. The people are the sovereigns under our constitution. Let there be no doubt about that. Because I believe that there is some feeling, which is the same feeling that the government had at the time of Madhavrao Sindhya, that some level of paramountcy, some level of sovereignty had devolved on the executive. So an executive has some residue power by which they will interpret the constitution differently. They will use definition clauses where they can't touch it directly. My Lord Justice Khanna on day one was considering the proviso to Article 370 and said, look, that's a proviso. But the proviso is perhaps the most important thing in this constitution. Constitution amendments in this country have been struck down on only two grounds, only two. One was basic structure, the other was a proviso. The proviso in 368(2) was the reason why in Quixote Holohan, para 7 was struck down. Again, the amendments that were brought in for cooperative societies, your lordship struck down because it didn't meet with 368(2). I remember, my lord, the Chief Justice mentioning on day one about 368(2) proviso. Can you use that by way of the 356 route? I think that's a fantastic question. That's the heart of this case. Can you do that? Can you use 367? Can you use 366? Can you go sideways? The proviso provides the procedure you will follow, and you, creature and servant of the Constitution, will use no other procedure. We are not sitting here in deference to our equals. Our elected representatives have taken a choice. They've made a choice that they will follow the Constitution. Their oaths bind them to it. And they decide to follow devices like this. And they possibly don't learn from the lessons of the past. And I want to show your lordship the language of Justice Hidayatullah, Justice Shah in majority, Justice Hegde concurring in Madhavrao. It completely, in my view, covers this case fully. It's the exact same thing. In fact, it's less complicated, less experimental. But I'll come to that. That's the history part. On 370, because these words are very, very important in our constitution. We can't read them as out of context specific provisions with specific words. The words temporary, the words consultation, concurrence, necessary, recommend, the non-obstante clause, even the colon. There are 3 colons in Article 370. All of these are found in other parts of the Constitution. So if your lordships were to look at this provision in isolation and interpret it without at the very least considering the other provisions where similar words are used, we would have a problem that will arise on a future date, which is why I want to address your lordships on those. Then on the frauds on the Constitution and the measures which keep those provisions intact. 3 of them in particular. The ordinance making powers, which are exceptional. The expressions your lordships have used are necessary evils, but with safeguards. And what is that safeguard? That it will be temporary. Immediately after the legislature comes in, the legislature will look at the ordinance and decide whether they want to continue or not, as they have done in recent weeks, as far as the NCT of Delhi is concerned. Article 356, about how it will be exercised. There are safeguards in the Constitution. And see the orders they pass under 356. They suspend the legislative assembly. Once they suspend, and suspend has no other meaning in law. It has absolutely no other meaning in law except that it is for a fixed time period. It's in the interregnum. It's between 2 things. I haven't terminated. I haven't ended, killed, murdered, buried at 9 feet, 6 feet under. I haven't done any of those things. It's just suspension. What is the effect of that order today? Exercising 356, they suspended the Legislative Assembly and poof, disappeared. What's happened to it? These are series of abuses of the Constitution which has taken place in this case. And finally, my lords, there is one aspect which I thought is interesting and disturbing at the same time. In 2018, coincidentally, just a month before the events which transpired here began, our friends across the border did something unusual. Pakistan occupied Kashmir, they have another name for it, and Gilgit-Baltistan are the two areas which Pakistan claims as its own. In their constitution, there's no reference to that as part of their territory. And I think advisedly so for their sake, because they still harbor some hopes that there would be some accession of Kashmir to them. In 2018, they decided, one, to pass an amendment to their 1974 interim constitution for, as they call it, Azad Kashmir. The other thing they did was, in the same month, they decided to pass a GO with reference to Gilgit-Baltistan, which is the other area which is also across the border, all part of erstwhile Kashmir, or continues to be part of Kashmir. In fact, section 47 of Kashmir Constitution, you will find a reference that the territory of Kashmir as defined in the Constitution is the territory as it was on 15th August 1947, which is the entirety of it, without the 75,000 square kilometers having gone to Pakistan. Both that amendment and that order, what it did was to take away the right of self-governance that the people in those two areas had and to vest it in themselves. As far as Gilgit-Baltistan is concerned, it was challenged with the High Court. High Court allowed the challenge. It was reversed by the Supreme Court, which strangely substituted the impugned order, which had been passed by the government, with an order of its own. Effectively, what the government there has done is to wrest direct control and vest it in a council with the Prime Minister. I ask myself that question, isn't India different? Are we not a democratic country run by a constitution? Do we not adhere to certain promises that we make and which are covenanted in the Constitution as a solemn promise on which 5 constitution benches have weighed in? Or are we going to follow the ill-advised example of people who put their prime ministers in jail? Now, if your lordships have that note, I am not sure if it's been uploaded.
It's, we've got it there.
Sorry. If your lordship can then just skip quickly down to page 2, my lords. I won't take long. I've just given the outline already. From page 2 onwards, I'll just quickly read out the headlines. This is the sequence in which things panned out. Cabinet Mission Memorandum on State Treaties and Paramountcy, that was in May 1976. The second para there refers to how the rights returned to the states from the crown. This is important apropos what your lordship said earlier, observed on sovereignty. So what the British crown had taken, the British crown gave back to the states. So after that, it was between the states and the new government of India to enter into whatever arrangements, which is why the Government of India Act 1935 had to be amended. This is echoed by the Cabinet Mission at the bottom of that page. Next is the Negotiating Committee. This is on behalf of the Princess. Yeah, Asli. That's point number C. Then Mr. Vallabhbhai Patel's statement in July, a month before independence, my lords. If I can read the last 3 lines of the first paragraph and the second paragraph. We ask no more of them than accession on these 3 subjects in which the common interests of the country are involved. In other matters, we would scrupulously respect the autonomous existence. Next para, last 3 lines again. Nor would it be my policy to conduct the relations of the new department with the states in any manner which favors the domination of one over the other. If there would be any domination, it would be that of our mutual interests and welfare. Then the Indian Independence Act, these are the 2 relevant sections. Then the Government of India Act, the amendments I've referred to, my lords, that's 5, 6, 290 and 290A. H, this is the three routes which are set out in the white paper. H, the integration of states did not follow a uniform pattern in all cases. Merger of states in the provinces geographically contiguous to them was one form of integration. The second was the conversion of states into centrally administered areas. And the third, the integration of the territories to create new viable units known as unions of states. Each of these forms has been adopted according to size, geography, and other factors relating to each state or group of states. If your lordships were to tap on refer table 2, it will take you to a table. If you just tap on that. Now that table splits these states into three types. States that envisage their own constituent assembly, which are Madhya Bharat, Pepsu, and Rajasthan. Second, states that ultimately formed a constituent assembly, and there are quite a few of those. There's Mysore, Jammu and Kashmir, Junagadh, Saurashtra, and Travancore and Cochin. So because this question of constituent assembly came up, your lordships need to know that there were these 4 states which had constituent assemblies, but how 3 of them decided to go ahead with the Indian constitution after extended negotiation. The 4th one was Jammu and Kashmir. The table below shows your lordships each, I'm sorry, my Lord Justice Call has that?
Yes, yes.
Yes. The table below has princely state, the date of the instrument of accession and a supplementary instrument if at all, the constituent assembly if any, the remarks against that, and the source. I've given your lordship the volume and the PDF number. And we have shown how Jammu and Kashmir is the only one where that constituent assembly went ahead and formed the constitution. I'm not going to take more time. Your lordships will see the table whenever you have leisure, my lords, if your lordships have any leisure. Can you click on back on top to take you back to the beginning? At the top of the page, it says back on top, on the top right hand. If you just tap on that, it'll take you back to the note. The next was supplementary instruments. I'm sorry. Access. Hello, Justice Gawa, you have the note. No, but I don't know if they each of them will be. But do they even like that? Yeah. Okay. I'm sorry, could I assist if there's any difficulty? No, I don't know if we have it. I think it's across. No, it's too big. I think. Blue screen, we don't have to look at that. And put it here. No, it is- Yes, Manoj, are you back?
Lots of arguments.
I'm not sure. Huh? Page 4, I think. Page 4. Okay.
After table 2.
After table 2. Yes. Supplementary instrument. I'm sorry?
States with constituent assemblies. That's para 2.
Yes. Page 4, Manoj, bottom. We, in fact, looked at the guidelines the court had issued yesterday for written submissions, etc., which says PDF and page number has to be the same. So we tried to align that.
We're reading the white paper, no?
Yes, Manoj. That states with constituent assemblies, there are those 2 bullet points below that. 7 princely states. Your lordship have that? Bottom of page 4.
PNRO committee.
Yes.
ये तो जो हम शो करते बोल रहे हैं लॉजिक के पास आया वो पर्सनल किसी से थोड़ा टाइम लेगा कोई बात नहीं.
We saw Sardar Patel's statement. Now where are we?
Yes, bottom of page 4, states with constituent assemblies. Lordships have that?
Yes.
So these just give you the data points. 7 had covenants to form constituent assemblies, 4 formed them. And then the next page top, page 5 top, is the extract from the white paper.
ये देखो ना संजीव.
In existence, namely Saurashtra, Travancore, Cochin, and Mysore, the Saurashtra Constituent Assembly adopted the draft constitution in its entirety. The other 2 constitution-making bodies proposed a few amendments. Some of these were incorporated in the amendments finally accepted by the Constituent Assembly of India. Others were dropped as a result of discussion with the delegation of these assemblies. Our next para deals with Kashmir specifically. The state has therefore, I'm sorry, the lordships have that?
Yes.
I'm looking.
Yeah.
Yes, the state has therefore been included.
The state has therefore been included in Part B states. In view of the special problems arising in respect of the state and the fact that the government of India have assured its people that they would themselves finally determine their political future, the following special provision has been made in the constitution and 370 is extracted. Your lordships can see that first part of 370. Now, there is after that, from the J&K Constituent Assembly debates, Mr. Beg, speaking in the Constituent Assembly, also mentions why it is exceptional, why 370 is unique. Why was a special position, your lordships have that bottom of the page. Why was a special position granted to Kashmir? It is because of its special character and the struggle for freedom which the people of Kashmir have led. Kashmir, sorry. Kashmir, sorry. Appropriate, huh? The second sentence there, Kashmir, let me say, is the only state with this composition of population which chose voluntarily to accede to India, and we are happy about it. Within brackets, cheers. This is the first reason. Secondly, Kashmir has a strong popular movement behind it for which it fought for 21 years. That movement was for the establishment of communal harmony and welfare of the masses. Kashmir has before a definite socio-economic program of its own. As an honorable member of this house has said, it is with a view to implement that program that we acceded to India and we maintained special position. In order to implement that program by common consent and agreement during the time of Sardar Patel and other leaders.
Yeah.
And other leaders of India, special position was given to us. Therefore, any question of having given this special position to us for a temporary period does not arise. It was never given to us because our question is hanging fire in the UN or because Pakistan put forward its right over Kashmir, but because of the reason I have mentioned. It is a special position, and taking it away will clearly be betraying the people of Kashmir. We made our mind clear to India, and I'm glad it was understood by the Indian government. Honorable members of this house have expressed their doubts as regards the residuary powers, etc. Then Dr. Rajendra Prasad's note as president. This is sent to Prime Minister Nehru on 6 September 52. There can be no doubt that Article 370, and particularly Clause 3 thereof, is of an exceptional nature. While it safeguards in Clause 2 the right of the Constituent Assembly of Jammu and Kashmir to revise or annul any action taken by the government of that state in giving concurrence under Clause 1B2 and the second proviso to Clause 1D of Article 370. It excludes altogether the Parliament of India from having any say regarding the Constitution of Jammu and Kashmir and places full power in the hands of the government, including the power to amend the Constitution of India. It is therefore necessary to examine the wording of this peculiar clause with some care for a correct application of the comprehensive terms that Parliament could never have intended that such an extraordinary power of amending the Constitution by executive order was to be enjoyed without any limitation as to the number of times on which it could be exercised, or as to the period within which it was exercisable, or as to the scope and extent of the modifications and exceptions that could be made. It cannot be seriously maintained that for all time to come, the application of our constitution to Jammu and Kashmir would derive its authority from Article 370 to the complete exclusion of Parliament. The marginal note to Article 370 itself describes the nature of the article as temporary provision with respect to the state of Jammu and Kashmir. Please mark this note. The conclusion, therefore, seems to me to be irresistible, that Clause 3 of Article 370 was not intended to be used from time to time. The correct view appears to be that recourse is to be had to this clause only when the Constituent Assembly of the state has been fully framed. So it's a one-time exercise as far as 370 Clause 3 is concerned. I know it's troubling your lordships about 370 being a temporary provision. Our case, at least my case, 370 Clause 3 is a one-time decision-making exercise to be carried out by the Constituent Assembly. If abrogation is to be done, it's to be done once. And if it's done, 370 is out of the window, no problem. But if they did what they did in 1952 and decided to have their own constitution, 371D then continues to operate and has been utilized precisely like that. And that's why Sampath Prakash said it's permissible.
Gopal Sankaranarayanan,
Yes.
this entire version can be read differently also, against you also. That it was made as per Dr. Rajendra Prasad, that will be, clause 3 will be adopted and applied by the Constituent Assembly, and it will be abrogated forever. It can be read that way also. If you read it, carefully, that's the,
Even if I were to read it like that,
that's the,
one thing is very clear.
if you read
He
it,
says
just
that it
read
can
now,
be used.
just read what you have said.
I've read that. I've read that. So he is very clear about one thing, about taking out clause 3 and referring to it. That he's very clear about. He's also very clear about it not being used repeatedly.
We can't.
No, I'm saying there's no two ways. I don't think the President of India was under any misapprehension of what the
Just
Constituent
read the
Assembly
first
of Jammu and
portion.
Kashmir was.
If you read the first portion,
Yes,
probably the entire context in which he is saying is
yes.
this, there'll be Article 370 will probably not see the light of the day after the Constitutional Assembly of J&K.
The abrogation.
Exercises the power and the clause 3 of
It is
370.
temporary to the extent of abrogation. To that extent. To the rest of it, which is why 370 clause 2 is transitory. 370 clause 3.
I'm not for the moment suggesting what the interpretation should be.
No, I agree. No,
What
but
I'm-
it's food
what
for
I'm
thought,
only-
definitely.
What I'm only
Yes.
trying to point out is
Yes.
there are two ways to look at the speech.
Yes.
Context in which if
Yes.
contextual interpretation is to be adopted.
If your lordships were then to see the entirety, because what I've extracted is page 774 and page 778, 779. If I read the entirety of it, which will take some time, I don't think your lordship will be left
We'll
in any.
examine that, we'll examine.
Yes, I leave it to your lordships to examine. Just see the whole letter. There's no doubt. There are three things that the president does. He takes up 370 clause 3, tries to understand its implication. He refers specifically to the Constituent Assembly, and he makes it clear that this is not a step that can be repeated. Those are three things that I adopt. Now, I have made a reference here, Manoj. This is only because the entire history with reference to all these aspects were also culled out by Justice Hidayatullah in Madhav Rao Scindia's judgment. So I've referred here, but your lordship can just jot on the side, paras 5 to 15 of Madhav Rao Scindia, which volume? It's here only, volume 6. Volume 6, PDF pages 419 to 425.
PDF pages?
PDF pages 419 to 425.
That is Mother of India.
It's written here, Manoj. Your lordship can see. It's volume 6. Starts at 420.
You need not do this.
Starting pages.
You need not do this.
Starts at 390.
Confine yourself to that other one.
Yeah.
6 pages.
It starts at page 390. PDF 390.
So, Mr. Shankaran, you've given us a 143-page note.
That's only a table. Your lordships, 60 pages of that is that constitution comparison. I'm not even going to take you through it. I'm just putting it because you need to have the material. Because all of this couldn't have come in our written submissions in advance. When your lordship put those questions saying we want to see the comparison, we had to respond to that. So I'm not going into any of that.
Now, how much more time, Mr. Shankaran?
I'll wrap up, Manoj. I'll wrap up. I'm just going quickly. That's why I'm not showing your lordships too much.
So let's.
So this was primarily to show the unique nature of Kashmir. I'm sorry. In fact, it's interesting that for Kashmir, we had a ministry in the union government, the Kashmir Affairs Ministry, which was headed by Iyengar. But for everything else, it was Sardar Patel. And apparently there was a little bit of kind of discomfiture between the two of them about that. So Kashmir's unique position, and the reason why I'm saying this is because in the second NCT judgment, your lordships have unanimously looked at 239 AA and Delhi as being not just a simple union territory like the rest of them, but being a little different. I'm canvassing the same for Kashmir. It's very clearly different. There is a different arrangement. Its inception was different. Its birth was different. Its life has been different. It's got a constitution. It's been running 70 years. Now, if you're going to upset it on a mere ipsi dixit overnight, there's obviously some basic procedures and protections which are provided in the constitution have to be met. That's all we're saying. We're not saying that you can't do this, especially when we have reached this far. In 1908, I'm sorry to digress, But in 1908, in the marathon in the Olympics, there was an Italian man who was a male man who took part in the Olympics.
Yes.
His name was Dorando Pietri. Dorando Pietri reached, after finishing the entire 42-kilometer stretch, reached the stadium, and I think it was Paris. And he ran into the stadium, and then he was so exhausted and dehydrated that he was collapsing. So thrice the umpires, referees, people who were standing near, helped him pass the finish line, and he came first. And then they stripped him of his medal. They said that you took help, and the rules don't permit you taking any help of any sort whatsoever. But he did running himself, and they disqualified him. The reason I'm mentioning this is pretty much where Kashmir had come with adopting India's constitution. We had entered the stadium, Kashmir had entered the stadium, it was near the finish line. There was an illegitimate assistance given to get it past the finish line, which is completely unnecessary. Completely uncalled for, contrary to procedure. You lose a gold medal as a consequence. Also, Manoj, the promises that were made at the beginning of the constitution as against now. There was the people of Kashmir through the Constituent Assembly took the decision not to anyway adopt, exercise Article 370 clause.
Maybe not, I mean, just as a hypothesis.
Yes.
It's sort of worrying me, and therefore I'm putting it to you at this point, maybe a little digression.
Yes.
Can we not possibly read Article 370 as indicating two terminal points?
Yes.
The first terminal point is in clause 2 of Article 370, namely the formation of the Constituent Assembly of the state for the purpose of framing the constitution.
Framing the constitution, that's correct.
The second terminal point is indicated in the proviso to clause 3.
Yes.
That again refers to the recommendation of the Constituent Assembly.
Correct.
Interestingly, 370 is silent on what the regime should be once the Constituent Assembly is formed and has taken a
That is
decision.
correct. Which is why two views.
There's complete silence.
Yes.
Right?
Yes.
If there is complete silence in Article 370, then 370 possible interpretation has worked itself out both in relation to clause 1 and in relation to 2 and 3.
That's a possibility.
Right? In which case, once that happens,
Yes.
then we have two options.
Yes.
Your line of thinking would be then, but therefore then the constitution of the state of Jammu and Kashmir will fill in the void, and that will trump, and that will be the supreme document.
Yes.
The other view possibly is, can the constitution of a federating unit ever rise above the source of the federating unit? Because we've always sort of presumed, because, the COs sort of led us up a certain line of thinking.
Yes.
That may have been done. That may have, we're not saying at all that was unconstitutional. It would be very, very improper. I mean, not improper, but obviously these are statesmen who have operated this nation for the last 70 years. And we shouldn't say that, well, they did something which is unconstitutional. They did that to sort of further the course of governance in the nation.
But the judgment in Sampath.
They did that to further the course of governance in the nation. But if the terminal point of 370 is the Constituent Assembly's work,
yes,
then is it not necessary that the work of the Constituent Assembly of the state of J&K has to be embodied in this constitution to make it operational?
It's not necessary, because it's not provided for by the constitution. The constitution looks at the Jammu and Kashmir
It
constitution.
depends on what view of our federation we take.
Yes.
And if that is not so,
Yes.
then is it not also possible to a construction, then where was all this exercise necessary? Abrogation and everything.
Yes. No.
Abrogation postulates that it continues. Could be, yes, as we ourselves said, that they applied 370 even post 1957 by all those COs.
Correct.
But if 370 works itself out,
No, if it works itself out, I'm with your lordship. I think we must rethink all these different ways of looking at it. But if it works itself out, it can't be touched thereafter. It's worked itself out. It exists in the constitution.
no, it doesn't exist in the constitution.
No, I'm
It's a provision.
clearly on the text.
No.
Without being able
But
to
it's
be touched.
completely, but the text, it is there in the constitution,
Yes.
but it's a provision of the constitution which itself points out its self-limiting character.
No, and
Right. So it's not obliterated. But if the text itself shows its self-limiting character, then the very operation of 370 has to come to an end once the Constituent Assembly of the state was formed. And that is a key reason why both 2 and the proviso to 3, that you are in a way possibly right. I mean, we'll have to, of course, when I say you're right, it's part of the process of reflection. We have only finished half the arguments in the case, on the anvil of finishing half the arguments. That the proviso to 3, when it speaks of, it doesn't say, what does it say?
necessary.
Declare that this article shall cease to be operative or shall be operative only with such exceptions or modifications.
Yes.
This exceptions or modifications finds expression in 2 parts of this Article 370.
Yes.
Clause D.
Yes.
D refers to subject to such exceptions and modifications
Correct.
as the President may specify.
Yes.
The second is clause 3.
Yes.
Shall be operative only with such exceptions and modifications as he may specify.
Yes.
So, if you see A 238 will not apply. If 238 applied the was part 6 of the Constitution.
Yes.
Part 6 of the Constitution dealt with the executive, the legislature, the governor, the high courts, and the subordinate courts. There were 5 provisions of part 6.
Yes.
That will not apply. If that will not apply, what would apply? It can't be that there was no executive, governor, legislature, high court, or subordinate courts in Jammu and Kashmir. 1939 arrangement would apply. All right, that's an indication of its being a very pro tem sort of a measure. Then Parliament may modify. Parliament may make laws with respect to those which are covered in the instrument of accession.
That's describing power of Parliament.
For Parliament.
Yes.
Then such of the other provisions of this Constitution, then comes Article 1 will apply,
Yes.
right? Then D says such of the other provisions. Now, which are the other provisions? Other than what is stated in clauses A to C,
Yes.
that is 238, power of Parliament to make laws, Article 1.
Yes.
Such of the other provisions will apply with such modifications and exceptions as the President may make.
Yes.
All right? No such matter which pertains to the clause 2 will be made unless, it has the concurrence of the state.
Yes.
Then why does 2 come in? 2 comes in that in case the consent was given before the Constituent Assembly was formed, place it before the Constituent Assembly. So,
Yes.
terminal point of clause 2 is the Constituent Assembly.
Yes.
What does 3 say? Notwithstanding anything in this article, notwithstanding not anything in the Constitution, but in this article, the President may declare that this article will not apply, not any other provision.
Three, in my view, overrides 2 and 1.
Absolutely.
3 stands right at the very top.
Because of the notwithstanding,
Which is why, just
non-obstante
read the
clause.
1952 order for a minute.
Right, so that
Which is in terms
1950,
of 3.
right, 1952 order therefore was the only order before 2019 which applied clause 3.
Correct.
The point now is this,
Yes.
that is there not intrinsic evidence that 370 itself is self-limiting once the Constituent Assembly has come to an end?
As far
And
as we
if
are
it is
concerned, 370
self-limiting-
clause 3 comes to an end with the Constituent Assembly. That's our argument.
But then the point is this, then do we say that our constitution must be so read to treat the constitution of J&K as an overriding document which will apply in preference to our
Because if you
constitution?
see the Constitution of Jammu and Kashmir, it differs to the Indian Constitution.
Absolutely, you're absolutely right.
It only
In
makes
which case-
small nominal changes. And
In
all
which
its-
case,
yes.
really speaking, though the constitution of J&K framed its relationship with the Union of
Yes.
India,
Yes.
unless that relationship was embodied in the Indian constitution, how will it bind the Dominion of India or the successor parliaments of the executive here?
For the simple reason that when the Indian Constitution specifically recognizes a Constituent Assembly for only one state in the country and says that Constituent Assembly has the task of deciding to abrogate the clause or not, the Constituent Assembly and its task, which is described in clause 2, is constitutionally recognized. So the fact that there is a constitution coming at the end of this is an obvious corollary.
Does that mean that therefore anything that was said by the Constituent Assembly of J&K would bind the nation, bind parliament or bind the executive here?
Couldn't.
It had to be embodied subsequent to 1957 in a binding arrangement reflected in our constitution, which was never done.
That, my lords, with
Because everybody started working on, a working arrangement. The idea was to sort of, gradually bring J&K into the mainstream. Therefore, they didn't want to do that.
which is thankfully what has happened, and which is why if we take the extreme position that there is no question of 370 subclause 1 continue after 1957, Lordships, sorry.
The Shankar,
370
at
close.
340 will, now I think 340 we will finally wrap up and
think-
give
I
them
mean,
20 minutes to
This-
start
this
opening
is
the
not
debate.
anything that has been said before, which is why I'm saying it. So I in fact abandoned this interpretation of 370 except to say one last thing. 370 clause 3 says President may. So 370 clause 3 need never have been operationalized. Please note that. If the recommendation didn't come from the Constituent Assembly at any stage, then the president would have nothing to decide a recommendation on. So while the Constituent Assembly was on, if 370 clause 3 sat there quietly in the waiting room and was never called in, and then the Constituent Assembly went after the Constitution came in, 370 clause 3 would expire there without it ever having been operationalized because it's a question of may, necessary, recommendation, Constituent Assembly. With those four absent, there's no question then of it being operationalized. But your Lordship's question on Jammu and Kashmir Constitution being recognized here, the Jammu and Kashmir Constitution refers to the Constitution of India as it goes through its avatars. That's in the definitional clause. There are several articles that refer to the Indian Constitution. All the COs that came after 1954 and including 54 refers to the Constitution of Jammu and Kashmir. So as Mr. Subramaniam said, there is a bridge and that acknowledgement is there even in correspondences which have been shown to that extent. But the answer has to be no. If your Lordship's question is the Constitution of Jammu and Kashmir referred to in the Constitution? No, it's not. But it's understood that it's there. It's a classic federal situation like in the US, where states have their own constitutions, flags, etc., etc. Yeah, that's. Now, the next point, Manoj, page 8. This is the earlier attempt to abrogate Article 370. If your Lordship sees, this is to omit Article 370. Just a couple of paras. This is on the right side, if your Lordships will see Sri Nanda, right side column at
Yes.
page 8. He's the Home Minister at that point. And let me just show your Lordships after the extract, and this extract is important. But I don't know if your Lordships were shown that 368 has a proviso in its application to Jammu and Kashmir. Now, because of that proviso, I have to differ a little bit from Mr. Sibal's interpretation. When your Lordship asked, what are the ways they could have done it if they didn't adopt 370 clause 3? My response on that day and this is 370 subclause 1D is the only way they could have done it by following the procedure under 1D. What they would have to do under 1D is as follows. First, they would have to get rid of this proviso under 368 because the proviso requires that every time India's constitution is amended.
They have not done it, they have not done it.
They haven't done it. That's,
No, if they do it, we'll see how it is to be tested, that's all.
yes.
Why
But the
should
reason
we-
why I'm giving the solution to the
We are also
government.
We are not
Yes.
an advisory jurisdiction to tell them how to do it, how not to.
I know, but the reason
not
I'm
our
telling
scope.
them, I need to tell them how to do it, not for my sake or theirs, but to
We are only
satisfy the
examining as to
conscience.
what they have done is correctly done or not.
I agree.
They have
We are not here to give them advice as to what
We
they
are
should.
saying they can't do it.
Yes.
We will determine could they do
Very-
it or could they not do it. At this stage, if they need your advice, they will ask you whether to do it in another manner.
Very well. So he won't, I may. The reason is that it troubles your Lordship's conscience, and I can understand why. If there was absolutely no way of totally integrating Kashmir with India, that was never at all considered. There is a legitimate way. They know what the legitimate way
It's
is,
happening.
That's
It's
it.
happening over a period of time. COs have been issued.
and it will come to its
So
logical
is
conclusion.
whether the further movement of the remaining assimilation
Yes,
could have been done by this method or not. That's all we are testing.
that's exactly what we're saying. And that is why Mr. Nanda gives the reasoning. Next page, if your Lordship sees page 9. This qualification or this proviso, which excludes the scope of amendments to 370 without certain steps having been taken under 370 itself. We cannot amend the constitution. Those steps have not been taken, and therefore this bill will suffer from an inherent disability. This may be taken up later on if need be and if necessary, but apart from this, I can leave the rest of that. Next para, this is important. The position is this: while the rest of the contents of the constitution to which I have made reference negate the application of the provisions of constitution to Jammu and Kashmir, some of them by extension, others directly. The only avenue of taking the constitution into Jammu and Kashmir is through the application of the provisions of Article 370. That is the only way of bringing back the constitution in J&K. That is my reading of the constitution. Then the sentence about the tunnel, and I say, may I submit to him and the other friends that Article 370 is neither a wall nor a mountain, but that is a tunnel. And he explains further that at the bottom of the page, why he thinks 370 is beautifully conceived, etc., etc. I won't spend any more time on that. On the next is my interpretation on 370. There are a few tables which are annexed to it. The first is with reference to temporary. If you click on table 7, Malor, it shows all the temporary and transitional provisions as on 26 January 1950 in part 21 of the Constitution. I've included those which have subsequently been repealed by the 7th Amendment. But all of these, and the second column shows which are temporary, which are transitional. The head of the chapter, if your lordship may note, initially said only temporary and transitional. Special came later by way of an amendment. So it wasn't there initially. They were only temporary and transitional. And these are the provisions. Your lordship can go back to top. Also, because I think perhaps we shouldn't pay too much attention to this marginal note and temporary troubling us, because there are many provisions across the Constitution outside of Part 21, which are also temporary in nature, which is in Table 8. And the last column in Table 8, if you click on Table 8, the last column shows what those provisions are predicated on until a law is made by Parliament, etc., etc. For example, appointment of the Election Commission, your lordships found that there was a void, and until a law is made, your lordships provided a mechanism. Now the government realized that mechanism should have come much earlier, so they've made a law. The time periods, just for a minute, if you see 334, Article 334, Anglo-Indians, their reservation has come to an end. 70 years has been substituted and remains substituted, but for the SC/ST, they made it 80 years. So that's a temporary provision. It was allowed as long as those extensions existed. I won't spend any more time on that, but just to say that when your lordship look at
73(2) is not a temporary provision. These are not Article 73(2), these are not temporary provisions. These are provisions which will continue unless varied by any law of Parliament.
Correct.
But these are not temporary.
No, unless an action is taken. So similar to 370 clause 3, where the action had to be taken by the Constituent Assembly but didn't happen. Similarly here, where Parliament has to make a law but doesn't make a law, it becomes predicated on an action by one of the instruments. That's all. So we are pointing out that the other parts of the Constitution, like when you say 70 years, there's no doubt. It initially said 10 years for the reservation. So that 10 years is temporary. Otherwise, they wouldn't put a time period on it at all. I shouldn't give them more ideas, but they shouldn't put a time period on this. The reservation would go on forever. So the marginal note, Keshav Nanda's 4 judgments we have put there, which show that marginal note shouldn't really be used as an aid. This is only on the temporary part of it. Then, if your lordship sees para 2 on page 10, I've referred to table 1, which are the constitutional provisions applicable to Jammu and Kashmir. Just for a minute, if you click on that, I'm just rushing now. This is, your lordships have it on the screen. This gives you an example. The ones in green are the important provisions relating to Jammu and Kashmir. So the first column is the provision of Indian Constitution. Second column is that which was made applicable to Jammu and Kashmir with what modification. And the last column is the supplementing provisions of Jammu and Kashmir Constitution. It makes a very important reading because there are a few topics on which they had exercised their rights to have exceptions or modifications. Those are the ones in green: territory, permanent residence, property rights, fundamental duties have not been adopted there. Directive principles, they have what seems to be a more robust set of directive principles than we do in their constitution. Lok Sabha representation, services, consent for 352, 356, 358, then 367 and 368, and Schedule 7. These are broadly the ones in green. This is 60 pages, this document. My associates spent a lot of time going provision by provision of all three. to make sure that it can be an exhaustive table that's set out. If your lordships come back to the note, my lord, consultation and concurrence. Now, these phrases are used elsewhere in the Constitution. And it can't be that for purpose of 371D, where the impugn notification has come, that you've treated it so casually. Because there is this particular purport and a direction when you seek consultation and you get concurrence. In the demonetization case, Justice Gawai was part of the bench, and speaking through him, para 245 talks about the different types of consultation. These paras are set out. I'm not reading them. Second is the consultation which your lordships, in as far as appointment of judges in both SCORA as well as the special reference, you've read consultation in a particular way. So there is a meeting of minds. Now, it may not be the 124 interpretation that you have to have, but you have to some basic meeting of minds, as with the RBI in the demonetization case, as between the collegium and the government here, a certain meeting of minds. That meeting of minds doesn't mean your mind meeting your own mind. It has to mean some entity outside of yourself. You can't, by this device of 356, say, what do you think about this? And then tell yourself, oh, it's a great idea. Somebody else has to do that for you. And that's what they have sidestepped. And they've done it in the Constitution, which is why it's shocking. This is not some order by an executive of hearing. This is a constitutional amendment that you've effectively wrought about by way of this device. In Article 338B9, which deals with the OBCs and the commission required for that, your lordships in the Maratha reservation case said that the consultation there is mandatory. When you decide to add the Marathas to the lists, you should have consulted, you didn't consult. Now, all these are examples of where else in the Constitution you have consultation and what it means. And you're weighed in Constitution bench after Constitution bench, up to 9 judges, repeatedly you're weighed in to say this is what it means, this is the meeting of minds. That's completely thrown overboard by what they have done. Importance of the provisor, I've mentioned these two judgments, Quixote and Rajendra Shah. Colons, the Indo Development Constitution bench, links the proviso to the main provision, so there's no question about that. Recommendation, we have a table on recommendation, etc., which is table 6, which shows the many places in the Constitution where the word recommend is used and what its implications are. And it's necessary because it provides a kind of balance. A recommends to B. B can't set up A to recommend to B. A independently recommends to B. And that's also been thrown overboard. The non-obstante clause in Article 370 is very, very important. This non-obstante clause effectively trumps the other provisions in the Constitution which don't have non-obstante clauses. 356, 367, all don't have non-obstante clauses. Now, why does 370 say notwithstanding anything in this Constitution? It is so that in a situation where any of these other provisions could be in conflict, 370 is the one that will prevail. Which is why we have set out what those provisions are. The first bullet point talks about to Article 3, that proviso, which is in the if I can show in para 8 on page 15, just how Article 366 was misused in Madhavrao Scindia. 367 is being misused here. Just see, 367, you please note, falls in part 19, my lords. So it's not covered by 368(2) proviso. So everything in 368(2) proviso, which needs half the states to give its consent, they can do by way of 367. Just say for each of these articles, this provision will read thus. Examples. The word person in Article 21 can be interpreted to mean person accused of an offense. In 367, I'll put an interpretation clause which says person in Article 21 will mean person accused of an offense. So all other rights that your lordships have read into Article 21 is out of the window because it's only person accused of an offense. Why? Co-location, it's right next to Article 20, it's 21. So it's similar kind of people. That's the justification they could give if we allow this to happen. Using 367, the phrase the legislatures of not less than one half of the states in the second proviso to 368 could be read as the Rajya Sabha or the law minister. You could say that. We followed the right procedure. We followed a procedure of doing it by way of 367.
Giving all these ideas, Mr. Sankaranarayanan.
Which is why, please take a sledgehammer to this invidious method of trying to suborn the constitution. And the reason why I say this is because Justice Hidayatullah and Madhav Rao Scindia says we must take extreme examples to test what they are doing. Only when you take extreme examples, he talks about the Maharaja of Sindh and says, suppose the Maharaja of Sindh is now said to be the said to be the Nizam of Hyderabad. Of course, the president would never do anything like that, but we must take extreme examples for this purpose, which is why I'm forced to take these extreme examples to show that if they're allowed to do this, heaven knows what they'll do next. Now, I won't read the next bullet point for many reasons. Your Lordship may read it on your own. Well, if your Lordships come to page 17, frauds on the Constitution. Ordinances, 3 judgments on that, Wadhwa, A.K. Roy, and Krishna Kumar Singh, my Lord's Justice Chandrachud's own judgment. In fact, A.K. Roy is the other Mr. Justice Chandrachud's judgment. We have put both those extracts there so your Lordships can see. In fact, both your Lordships have spoken in very similar terms about how the Constituent Assembly held forth, as it were, an assurance to the people that an extraordinary power shall not be used in order to perpetuate a fraud on the Constitution, which is conceived with so much faith and vision. That assurance must in all events be made good. Your Lordships have said, an edifice of rights and obligations cannot be built in a constitutional order on acts which amount to a fraud on power. This will be destructive of the rule of law. Similarly, in precedence rule, how abusers are done, S.R. Bommai's paragraphs, Rameshwar Prasad, privy purses, I'll read separately in a few minutes. Possible consequences of such abuses, if you see point 5 at page 19, there's a separate table on this, where we have substituted legislature of the state with parliament everywhere in the Constitution, so you can see how absurd it becomes. Because by using powers under 356, can you do things which are irreversible and destructive? The idea of 356, much like 123, is a stopgap. It's in between. So that eventually Parliament or the government will take a call on it. It is not that you can do something completely irreversible and say, sorry, I had the power to do it. You didn't. Votes on accounts, GST, procedure of legislatures, panchayats, municipalities, even 246. Where list 2 is with the state legislature, Parliament can say state legislature is Parliament and then start making laws on its own. Surely that was not what is envisaged. Federalism and Article 3 has been exhaustively covered by Mr. C.U. Singh. I've just put some extracts of both the GNCTD cases, particularly to show that the GNCTD 2 is one that is, I think, very, very clear on the unique position. And one small thing at point 2, page 22, second point, 12 reorganization acts have been enacted. We have given that list, that's table 4. This is 2B, my lords, bottom of page 22. 12 reorganization acts enacted till date show that a state has never been annulled. The first one is this, where by way of this Kashmir Reorganization Act, entry 15 has been deleted, everything has been renumbered and moved up one. It's never happened before. All that's happened is union territories have moved into the state list. That's all. You never had a situation where the converse has happened. This is the first. But Mangal Singh, Mr. Singh referred to it. Mangal Singh effectively said that states must have legislature, executive, judiciary, etc. And all of these must be in existence. By going ahead, not following the procedure with reference to legislative council, you've heard that point already. So I'm not referring to that again. Yes, Mangal Singh is reiterated in Keshavananda Bharati. Your Lordship may see that. That's also
pointed it out.
Yes, yes. And point 4 at pages 25, 26, the irreversible effect on states' rights under the Constitution, points C, D, E, and F, Mr. Nafde made. A, B, G, and H is what we are canvassing. I just want your Lordship to chew on one point. If this were permitted in an Article 131 suit, which say the state of Punjab files against the Union of India, the Union of India will impose president's rule on Punjab, be on the other side, withdraw the suit and disappear. Article 356, the manner of the exercise. Those SR Bommai paras have been extracted, my lords. We have given an illustrative list, which is now in my written submission, the original written submission. I mentioned it here at page 28. Para 26 of the written submissions, which lists all the possible misuses that are possible under this. And one important point, my lords. What is permitted under 356(1)(a) is only for the functions of the government to be taken by the president. Functions, not powers. Now, what is provided in 370 is not a function with the greatest of respect, it's a power. 356 didn't permit it. Their proclamation under 356 is in the same terms, it says functions. So the only thing that could have been taken over was functions, not powers. So this was a power, and they have taken over what effectively is a power, and they've utilized it. I think this is an argument that they must meet. They must explain how possibly this was a function. A function under 356, which is temporal, is something which is a day-to-day activity which needs to be done. It's not a discretion which has not been exercised in 70 years suddenly becoming a function. I have pointed out how irrevocable changes cannot be made. And the last point, I've given your lordships the details of the judgments, the amendments, etc., dealing with Pakistan, Gilgit-Baltistan, as well as what they call Azad Kashmir. And hopefully we will not tread down the same path. I just want to conclude with one last thing, which I have set out. That's already been done. Which, page 16. This is Vattel's Law of Nations. It's a very, very old book. I'm grateful to Mr. Rahul Narayan who lent it to me. It's in fact one of the oldest books on international law and laid down the principles. George Washington didn't return his copy to the local library in Philadelphia, and they discovered it 200 years later. Now, if I can just read 2 paragraphs of this, it's set out at page 16. I'll just read that because I think it's important for us to bear in mind. Para 30. The constitution and laws of a state are the basis of the public tranquility, the firmest support of political authority, and the security for the liberty of the citizens. But this constitution is a vain phantom, and the best laws are useless if they be not religiously observed. The nation ought then to watch very attentively in order to render them equally respected by those who govern and by the people destined to obey. To attack the constitution of the state and to violate its laws is a capital crime against society. Please note this. And if those guilty of it are invested with authority, they add to this crime a perfidious abuse of the power with which they are entrusted. The nation ought constantly to repress them with its utmost vigor and vigilance as the importance of the case requires. And then, para 35. But in treating here of the change of the constitution, we treat only of the right. The question of expediency belongs to politics. We shall therefore only observe in general that great changes in a state being delicate and dangerous operations, and frequent changes being in their own official, a people ought to be very circumspect in this point and never be inclined to make innovations without the most pressing reasons or an absolute necessity. The fickleness of the Athenians was ever inimical to the happiness of the republic, and at length proved fatal to that liberty of which they were so jealous without knowing how to enjoy it. My lords, in Mother House India, I'll just give your lordships the paragraphs. Please read it at your own leisure, and it's very, very important. Justice Shah, speaking for 7 judges.
Mr. Sankaranarayanan, you said that twice or thrice at your own leisure, but have you left us any after this comprehensive?
I'm so sorry. I don't want to take more time.
Comprehensive, no,
Not
absolutely.
even leisure for now, for the next couple of months. No leisure.
I'm so sorry.
But
Your lordship,
we must compliment you and thank you and your juniors as well for putting this together, because this actually puts very, very, I was just telling Brother Sanjeev Khanna, very,
assisted
please
me.
tell your, all your
names. I put
instructing
them in the
advocates
written
as well.
summary, but they've been most.
You've put it all together, so it makes our task so much easier than to, constantly
I'm
cross-reference.
grateful. But just if your lordship can note, Justice Shah This is at PDF page 448 is where Justice Shah starts, speaking for 7. He's joined by Justice Hidayatullah earlier and Justice Hegde later. Paras 94, 111. Then Justice Hegde, who says it's fraudulent and for collateral reasons, at 173 and 176. Should I repeat those? 173,
You put it in the note.
No, that's not in the note. That's why I'm so sorry.
Just one second.
That's not
Just
in
come
the-
again then. This is Madhurao, right?
Yes. Justice Shah, paras 94 and 111. There's lots more, but I'm just giving you what I think is the most.
94 and 111.
Yes. Justice Hegde at 173 and 176. Paras 173 and 176. And Justice Hidayatullah at paras 42, 53 and paras 73. 73 is where he says extreme examples are necessary to solve extreme cases. Because I believe this is an extreme case, mainly because of the way they have conducted themselves. I'm most grateful for the patient hearing you.
Thank you, Mr. Shankar Narayanan.
Most grateful.